Hello and welcome. Today we are going to discuss about one of the greatest landmark cases which was given by the Supreme Court to the judicial system. Let's talk about the state of Haryana versus Bhajan Lal, which was decided on the 21st of November 1990. Let's dig into the fact of the case. Chaudhry Bhajan Lal, who was a former chief minister of Haryana and one of the biggest political figure during 90s in Haryana, was alleged of having wealth more than his income. The complaint against the former chief minister Bhajan Lal ultimately went through the Chief Minister Office and DGP, which led to the filing of FIR under the sections of IPC and Prevention of Corruption Act. Ultimately, this led Bhajan Lal filing a petition in the Punjab Haryana High Court to quash the FIR, which was later decided by the High Court that the FIR is going to be quashed on the basis of that it does not constitute any conjugal offences against the former Chief Minister. Ultimately, state filed an appeal in Supreme Court against the decision which was given by the High Court in this case. The decision of the High Court was set aside by the Supreme Court on the ground that the High Court acted prematurely in an ongoing investigation, but also the Supreme Court does not uphold the FIR on the ground that the SHO lack the legal authority of investigating under the Section 5A of Prevention of Corruption Act. This led to the Supreme Court give 7 landmark grounds on which an FIR can be quashed, and it can be justified by the High Court on the basis of its inherent jurisdiction. First, no offence made out. On this ground, if an allegation in a complaint does not show any crime, then the FIR can be quashed. Second, no conjugal offence is made out. When the offence which was registered in FIR or complaint does not make out to be a conjugal offence where the police can investigate without the order of a magistrate, then it can be quashed out. Third, if no proper evidence is found in the case which is related to the allegation made out in the FIR or the complaint. Number 4, absurd and improbable allegation. If the allegation made in the FIR or complaint does not constitute a crime, it can be quashed. Fifth, frivolous or malicious proceeding. If a FIR or a complaint is registered just to make a person miserable or to harass him without any genuine basis, it can be quashed. Number 6, malicious or malified intention. If an FIR is made with the intention to take vengeance or to the feeling of grudges, it can be quashed. Number 7, legal basis. If an FIR is made against an accused, in such case where there is a specific law made to not to proceed in the following case, then the FIR can be quashed. To wrap up with the state of Haryana versus Bhajan Lal, let's just say that the Supreme Court decision and outlining the 7 guidelines for the quashing of FIR put the judicial proceeding in balance. Thank you.